I'm still concerned about the anti-Muslim video and the subway signs in New York and these unbelievably stupid, offensive, insulting stunts here in this country, burning the Koran and so on, that are foreseeably going to result in danger, if not death, for our diplomats and Americans abroad. And I'm wondering, don't you think our government ought to be doing something about those kinds of provocative, hateful stunts? Should we sit idly by and watch those insults inflame people in various parts of the world and result in the death of some of our people? Nothing we can do about that? Anybody? Got a bright idea? Got any idea? Would you do nothing? I mean, the president goes before the UN and says, well, our First Amendment guarantees free speech, and we can't go around banning speech simply because it's hurtful, so on. Entirely in agreement with him. I'm surprised. What if that kind of speech occurred here on campus? Any different? Everybody shrugged it off. And free speech. We have nothing to say about it. Nicole? I haven't seen him. Somebody sits on a pillar? Well, what does he say? Does he attack people because of the way they look?
No, just like speaking,
religion?
And stuff like that. So I mean, in a way, like I guess I heard that often.
Mm-hmm. Yeah. So, does anybody engage with him?
He didn't actually engage with him. I think people engage with the school about Bible.
Mm-hmm. What about, don't people still set up card tables in Sproul Plaza and proselytize for their causes? And do you need a permit to do that? Yeah? You need a permit to set up a table in Sproul Plaza? Are there any standards for deciding who gets to do that? Do you have to promise if you're going to set up there that you won't disrespect or insult somebody's religion? No. Mm-hmm. You have any problem with that? No. Well, lots of people around the world have problems with that. I suppose pictures of the Abu Ghraib tortures and video of drone attacks various places. Remember, one of the drone attacks was on video in Iraq, where we took out a car full of people, which happened to include 2 Reuters journalists who were innocent victims of that attack. And Bradley Manning, everybody know who Bradley Manning is? You will next week or the week after. Bradley Manning, the young soldier who had access to classified Pentagon databases, was upset by this video, and apparently it still hasn't been determined. He's going to be subject to court-martial this year. Apparently leaked the video to WikiLeaks, which spread it around the world, which caused disorder, disruption, violence in various places. Should he be criminalized because of leaking that video? Should WikiLeaks be subject to criminal prosecution for publishing classified top-secret information, the video? If a conventional news outlet, television station or network, airs that video, and it causes harm somewhere in the world, should the television station be subject to sanction? Or do we just let that all go? Maybe Zero Dark 30 and the scenes of torture in the movie will cause violence somewhere in the world. Should we shut it down? Nobody wants to do that, right? And it's very hard to think of what, practically and consistent with the First Amendment, our government could do. They can take people by the shoulders or shake them and say, don't do that, or please don't do that, or if you do that, that's going to make a lot of people unhappy, including your government. They can try to persuade them not to do it, but if they use legal sanctions, that triggers the First Amendment. And what kind of a law can you write that would contain these outrageous stunts that people continue to do that cause harm in various parts of the world? Like last time I challenged you to draft a law. You can do it in your head. What kind of law can you draft that would solve the problem in a way that did not suppress protected speech? I can't think of any. But certainly there are lots of people who wish that it was possible to have a law to deal with that phenomenon. Okay, now let's deal with the only Supreme Court decision on the merits of a 21st century protest speech. And that's the funeral protest case, Snyder versus Phelps, that involves really unpopular speech right here at home. Fred Phelps, the founder of the Westboro Baptist Church in Topeka, Kansas, has this congregation of 60 or 70 members in the church, almost all of whom are his family. The congregation includes his own children and grandchildren and a few in-laws, maybe a straggler or two, but they are fundamentalist Christians, and among their beliefs is that God hates homosexuality and punishes America for its tolerance of homosexuality, particularly in the military. And in recent years, Reverend Phelps has gone around the country organizing picketing of military funerals. Somebody gets killed in Iraq or Afghanistan, soldiers brought home, funeral is held here, and who shows up but Reverend Phelps and his people. He just wants to make a point. They have a particular point of view, and they know that if they picket military funerals, the media will pay attention, and they get publicity. Their point of view gets communicated to a larger public. Well, in 2006, a Marine by the name of Matthew Snyder was killed in Iraq, and his body brought home. And his father had the funeral service conducted at a Catholic church in Maryland, and they put obituary notices in the newspapers, and Phelps picked that up and decided that he would take his people to Maryland to picket this funeral. And so Phelps and 2 of his daughters and 4 of his grandchildren showed up at the funeral location in Maryland with their hateful, ignorant, homophobic signs and picketed the funeral. Before they went there, they notified, they assumed that there would be some reaction to their doing this, so they notified the police. And they followed the instructions of the police on where they could set up their picketing. And it was about 1,000 feet away from the where the church was, where the funeral was conducted. And the father of Matthew Snyder was, Albert Snyder was his name, didn't actually see the signs during the funeral. He saw them on television the night, because the news covered the picketing, the night after the funeral. And he was extremely upset by this intrusion into his grieving about the loss of his son. And he therefore sued Phelps and the church for damages for invasion of privacy by intruding into this event and for the intentional infliction of emotional distress. Those are both common law torts, civil claims that support damages, if you prove damages from the injury. That is, intrusion into one's solitude in a manner that is highly offensive to a reasonable person is a tort for which you can recover damages. It's a tort that grew up at common law in this country in the 20th century. Judge-made law. And secondly, the intentional infliction of emotional distress, which pretty much describes what has to be proved in order to win damages, is a tort that grew up in the 20th century. And Mr. Snyder sued Phelps and the church for damages under these torts. The jury awarded $2.9 million in compensatory damages, plus punitive damages, for a total of $5 million. Just so you know, this doesn't have a whole lot to do with the First Amendment, but when people sue for damages, there are basically 3 kinds of damages. Compensatory, and that's to compensate the person who's injured for those injuries. And when you get in an automobile accident, for example, if you rear-end somebody while you're going 60 miles an hour down Hearst, and you rear-end them and bang into their car, they're going to sue you for damages. And by way of compensatory damages, we'll seek the damage to the automobile, what it takes to repair the automobile. Those are special, what's called special damages. Out-of-pocket damages. The hospital bills or the doctor bills for getting treated for the whiplash injury that you have caused, those are special damages. And then there are general damages, which consist of compensation for pain, suffering, embarrassment, humiliation, whatever the kind of general damages caused by your wrong are. Those are up to the discretion of the jury based on the evidence. The jury can award $300 for fixing the car, and $1,500 for fixing the victim physically, medical treatment, and $200,000 in general damages, just to take wild figures out of the air. So those are compensatory damages that are designed to compensate the victim. And then there are punitive damages, sometimes called exemplary damages, which are not, the function of punitive damages is not to make the victim whole, to compensate the victim for injury or loss, but rather to punish the wrongdoer, you, the rear-ended person, and to make an example, exemplary damage, make an example of you so that neither you nor anyone else will ever do anything like that again. Punitive damages are typically not available in automobile accident cases. They might be available in defamation cases, which we'll consider week after next, that is libel cases. And the prospect that someone will recover punitive damages, the jury might award $10 million in punitive damages to send a message to the press that has defamed someone that they can't do this sort of thing and won't be tolerated in our community, and this is entitled to make an example of that newspaper or whatever it was that did that, so they won't do it again. So those are the 2 kinds of damages that are typically available in civil lawsuits for damages. And in Mr. Snyder's case, he got both compensatory and punitive damages, adding up to $5 million. The church appealed to the Fourth Circuit, which reversed the jury's verdict, finding that the conduct and the speech, because this was both conduct, being there, displaying signs, and the words on the signs, were protected by the First Amendment. as applied to the states through the Due Process Clause of the 14th Amendment, right? Because this was a state law, common law case. The First Amendment itself doesn't have any application. It only binds the federal government. Snyder versus Phelps involving only a state law claim, but the states can't deprive a person of life, liberty, speech, without due process of law. So the Fourth Circuit reverses, and Mr. Snyder took his case to the Supreme Court of the United States. These folks are principled and fearless. They picketed the Supreme Court of the United States with their awful signs on the day that the court was hearing argument in the case. And the case was argued on behalf of the defendants, Phelps and the church, by one of Phelps' daughters, who argued the case in the Supreme Court. They did a superb job. Then comes the decision in the case, which was quite surprising and surprisingly written by Chief Justice Roberts. Go. That's fine to ask questions at any point. You got to keep me honest in some way, otherwise I go astray. Yeah.
So they applied the 14th Amendment because the state wouldn't do like due process law when they were supposed to liberty of speech. But didn't it kind of go through due process when they had the court case?
Yeah, well, I agree that the use of the words due process confuses people.
Yeah.
Because when you hear those words, you think procedure, trial, some notice and hearing. And somebody makes a deliberate decision. That's due process of law, rather than arbitrary grabbing somebody, clapping them in jail. Here we give people due process, that is, procedures which protect their basic rights. But the due process clause is not simply related to procedure and guaranteeing procedure. It is a substantive limit on what government can do to somebody. And a state, under the due process clause of the 14th Amendment, can't take away somebody's freedom of speech unless they do it lawfully. But they have to do it more than with a trial. They have to have justification for adequate constitutional justification for restricting the speech in question. I don't know whether that helps. Anyway, the decision comes down 8-1. Chief Justice Roberts, of all people, writing the decision. And it was one of the rare instances in which his opinion and the decision was consistent with his testimony given in his confirmation hearings when he was nominated to be Chief Justice, in that here is a decision that is extremely narrowly focused, fact-specific, no blunderbuss, broad-brushed, First Amendment preachy kind of stuff. It's very narrow and specific and commands almost a unanimous court to vote with him. Only one dissent, that from Alito. No new broad principles, and indeed it's hard to distill from Chief Justice Roberts' opinion what the principle of the decision is. Exactly what's the rule of law that the court used to decide the Snyder case. The court doesn't say that anywhere, but the court rather refers to a number of factors that played into the decision. And the chief one, as the Chief Justice said, that the decision largely turned on whether the speech in question was of public concern. And if it is, then it's irrelevant that the speech might be considered inappropriate or controversial or offensive, because if it is of public concern, then the public ought to be able to hear it. And he looked at the content of the speech, these signs and so on, and sees that the content is somewhat political, about our government policy with regard to gays in the military, for example, about the moral conduct of the United States, about homosexuality in the military, about the misconduct of priests in the Catholic Church, remembering that there are 6 Catholics on the court, and that some of these signs attack the Catholic Church, is some indication that the justices can get past their affiliations, their own personal views, and decide cases on a principle basis having nothing to do with their personal beliefs. And Chief Justice Roberts decides that the content of the Phelps speech was of public concern. I disagree with it entirely. It's not a refined analysis of public policy issues in any way, but it's about matters of public concern and therefore seemingly deserving of First Amendment protection. But he doesn't say that's enough to absolve the Phelps church people of liability in the case, and he points to other factors, other facts, that the picketers stayed 1,000 feet away from the funeral site. They were not visible from the funeral. They didn't disrupt the funeral in any way, didn't interfere with the service. And they were picketing in a public place, on a public sidewalk, a traditional public forum where people get to express their views. And then the court also pointed out that the father, Mr. Snyder, objected to the content of the signs. That's what upset him. That's what disturbed him, what the words were. A content-based objection to what the picketers had done.